Okay, hello to Miss Anusha and Mr. Nathan. Today, I, Mohammed Mazwan Khan, FIL July intake for the student number of 13604, will be talking about the essential problems faced in a court by trying to enforce contract. Intention to create legal agreement is an intention to legally to enter a legally binding contract or an agreement. Intention to create legal relation is also one of the necessary elements for the formation of a contract. It is because intention to create legal relation consists of readiness for the party to accept the legal consequences of having an agreement or a contract. Intention to create legal relation is a motion of every contracting party must have the necessary intention to enter a legally binding contract. Okay, contract can be divided into two parts. One is social and domestic, and another one is commercial. For the presumption for social and domestic is that the parties do not intend to have a legal binding, while for commercial, the parties intend to have a binding. Okay, for social and domestic agreement, it could be established in the case of Balfour against Balfour, which is a husband and wife case on 1919. So the case facts are the husband brought the wife from England to Sri Lanka, and the husband had returned to England, but the wife stayed at Sri Lanka due to medical reasons, and he promised to pay her £30 every month until his return. So when he failed to pay, the wife sued him because he failed to do the action which he said he would give her £30 a month. So the wife's action failed because there is no consideration moved from her and there is no intention to create legally binding agreement. So the court stated in husband and wife cases, burden of proof is on plaintiff to prove intention to create legally binding agreement. Lord Justin Atkin took a different approach, emphasizing that there was no intention to affect legal relations. That was so because it was a domestic agreement between husband and wife, and it meant the ones of proof was on the plaintiff, Mrs. Balfour. She did not rebut the presumption. The family arrangement approach in Balfour is not valid because they are separated or they are about to do so. This way comes married against married, which is in the case of 1970, if I'm not mistaken. So the case facts are husband left his wife living with another woman, and there was £180 left owing on the house which they jointly bought. So the husband signed an agreement whereby he would pay £40 per month to enable her to meet the mortgage payments, and if she paid all the charges, he would transfer his share of the house to her. When the mortgage was fully paid, she brought an action for a declaration that the house belonged to her. The court held that the agreement was binding. The Court of Appeal distinguished the case of Balfour against Balfour on the grounds that the parties were separated. Where spouse have separated, it is generally considered that they do intend to be bound by their agreements. The written agreement signed was further evidence of an intention to be bound, which states that the Court of Appeal upheld the wife's claim. Okay, moving into the second type of contract, which is commercial or business relation. So in terms of general rule, commercial relations or commercial agreement means there is a presumption or intention to be legally binding. Otherwise, in term exception, the presumption is rebuttable. For this could be established in the case of Kleinwood Benson Limited against Malaysia Mining Corporation Sdn Bhd. In this case, the plaintiff, which is the bank, agreed loan to MMC Metals, subsidiary of MMC. The bank asked MMC to guarantee loan. MMC said not policy to guarantee loans to subside offer letter of comfort stating, "It is our policy to ensure that the business of MMC Metals is at all times in a position to meet its liabilities under the arrangements." The bank accepted but charged higher rates of interest, and the market collapsed, and MMC went into liquidations. The plaintiff tried to claim the balance from MMC, but first instance the court found in favor of plaintiff, relying heavily on Skyway's 1964 ruling overturned on appeal, and the judge said Skyway's case was not about promise supported by consideration, so not applicable here. Hence, ruled no intention to create a legally binding agreement statement was not meant to act as guarantee, stating on current position, no, which means there is no future intention. That is all from me, Muhammad Mazwan Han, signing off. Thank you.